some of the challenges. Now, before in the first hour, you said that one of the reasons why you amend the constitution is to sort out any challenges that the constitution has. Is that a correct way of looking at it?
No. One of the things, one of the issues that you take into account is that, first of all, there has to be consensus that the Constitution is changing, meaning that there has to be a realization in the country as to the shortcomings of the Constitution. Now, in relation to this particular amendment, it is even very difficult to actually argue or support an amendment because this amendment was done in 2016. Now, we're in 2020, which is just 4 years. Now, how then do you determine the effectiveness of the Constitution when you have not allowed it to breathe? The ground on which it is found has not even settled. What is also important in this particular instance is for your listeners to know is that the Constitution as amended in 2016 has created a number of institutions independent of the executive. Those institutions have never been created. Now, how then do you assess the effectiveness of the Constitution when you have not even implemented it fully? So it is premature to even start tinkering. It's like trying to change something when the ink has not even dried. We need to allow this Constitution time. Let's see, let's experience it, let's test it, let's see how far it will come out alive, how it will perform, okay? And that is one of the reasons why we say, no, don't play around with the Constitution anyhow, okay? That is the point. For example, in 1991, why did we change the Constitution? Because there was a general consensus that, listen, one party state had not delivered. And there was a national consensus. Everybody, we were all agreed we should return to a multi-party political dispensation. And we did that. And the reason we changed the Constitution was because we believed that the 1973 one-party Constitution was not suitable for the new political dispensation that we are advocating for, which is a democratic one. That's how we changed. There must always be national consensus, because the Constitution is a national document. Every Zambian, every citizen has a stake in that document.
All right. Let's maybe you can highlight then.
Yes.
What you think are some of the bads that are in this bill.
Okay. Now, first of all, I have a problem. Not that I can't highlight, but I have a problem with such an argument, which is what the president is advancing. Yeah. I think he's missing the point. He's the one who made a decision to change the Constitution, to amend the Constitution. So he should be able to tell the Zambians, first of all, why. First of all, he has to start by convincing Zambians what is wrong with the Constitution as it stands, as it was amended in 2016. Now, various arguments are saying, they have been advanced to say, no, we need to refine it. So is he indirectly telling us that the people who put together the Constitution as amended in 2016 were incompetent, they didn't know what they were doing, or there were mistakes, and if there were mistakes, then fire them. Okay, then they did such a bad job. Okay, but the point is this, how do you turn around 4 years later and you want to change the very document that your government put in place? You need to have a stronger case to justify such a decision, and none so far has been presented. It is for the president to tell us the benefits, because we already have a system. It's working. And we are, and I'll tell you, our problem is not the Constitution. The Constitution is okay, perfect. And for me, I look at it to say the Constitution is perfect in the sense that it has significantly limited the powers of the president in a manner that no Constitution has ever done since independence. That is the reason why I support it. Now, if he wants to change it, it is for the president to make a case why he wants to change it. And so far, I have not heard a convincing case other than lies. For instance, the president is these days, you don't know how accurate the information is. But the president is on record as having said, well, we need support Bill 10 because it will improve, to stop chiefs wrangles. I think the Minister of Justice also said the same thing, to say, no, support it because it will solve chiefs wrangles and so forth. Now, those arguments are crazy, totally insane, because there is nothing in Bill 10 which addresses that issue. And anybody who goes on that path basically doesn't even understand how the institution of chief works. Now, succession is determined by the customary law of each particular tribe. There have been cases. Now, we're talking about an institution that the white man never destroyed. Over 100 years. Now, how have we managed to sort out chiefs wrangles in the last 100 years? How? Now, can somebody argue? These arguments are so baseless. Now, what would be convincing is to say chiefs wrangles is addressed in this article. That's what they should be able to tell you. But who has pointed out to any article in Bill 10 which addresses chiefs wrangles? Who? Who amongst all these PF cadres and ministers, MPs, and including the president, who has been able to demonstrate to say clause so is designed to address the chiefs wrangles? Who? Nobody has done that. These are just general statements being thrown around. Nobody has made such a connection because the connection does not exist. Others have argued, the vice president was on record as having said, no, this will help improve the economy. Now, can they tell us a clause in Bill 10 which will improve the economy? There is nothing. There is nothing. I challenge anyone who has read it, who can tell the country the connection between the economy and any of provisions in Bill 10. There is none. There is the thing that is peddled about this representation. What are they calling it?
Mixed proportional representation.
Yes. To say, no, it will improve the representation of the handicapped, the youth, the women. Countrymen, those are lies. They are lies. There is nothing in Bill 10 which addresses that. You ask them to point out to a clause which does so. There is no clause to that effect. What is there is, I'll explain. What they are trying to do is to repeal the system that we have right now and provide for a mixed member political representation. It's simply a concept. What they are trying to do is to introduce a concept into the Constitution. Now, there are various models of representation of members of Parliament. The Constitution does not specify which model they will settle for. This model, basically they are saying, let's approve it. We will now prescribe the model in an act of Parliament. First of all, it's crazy. It's crazy. Issues like that are so fundamental that they ought to be reflected in the Constitution. They cannot be a subject of an act of Parliament. Never in the history of this country has the composition, the mode of election of MPs been a subject of an act of Parliament. It has always been the subject of a constitution, starting from 1911, 1924, going back to the colonial days. The composition of the Legislative Council, later on the composition of the National Assembly, has always been the subject of the Constitution. What these people have done well is to tell us there are various versions of these systems. There is no version that has been prescribed. What they could have done is to be able to say, this is the system, so that we evaluate. I'm telling you, as a youth, as a woman, as a disabled, don't be cheated. There is nothing for you in Bill 10. There is nothing. The point is that this is not the first time that we have talked about this particular mode of representation. In the 2015 bill, that was draft constitution, there was a provision to provide for a mixed system whereby, if I may just, let me see whether I can find it and just read it for the benefit of your listeners. That was a system that was embodied in the Constitution. It was a mixed member system, whereby certain seats were going to be directly, they're going to be, people are going to be directly elected, and then certain seats were going to be split on a proportional basis. It had nothing to do with representation. The party was supposed to present a party list and so forth. That is a system. Now, there was extensive debate in the National Assembly as to why this system should not be adopted. And one of the reasons, the problem is that you see the parliamentary debates, they're now online. Anybody interested should go to the debates. I think it is December 2015. That system was rejected. It was there in the 1995 bill, which came out as the 1996 amendment to the Constitution. That system was rejected. They said, listen, the system you are advocating for is just too complex for our people to understand. Let's settle for a simpler system of first past the post. That is how that system was retained. So there is nothing whatsoever in the bill. Those people arguing in favor of the bill, they should simply identify a bill and tell us the benefits of that bill. Okay?
I just want to read, so Article 47,
yes,
as it currently stands,
yes,
right now, Article 7, Clause 2, elections to the National Assembly shall be conducted under a first-past-the-post electoral system,
yes,
in accordance with Article 68.
Yes.
Article 68 is the one that prescribes, and I'm just going to read it again,
sure,
for the benefit of
sure,
people. Article 68 says the member of Parliament shall be elected in accordance with Article 47, Clause 2.
Yes.
The National Assembly shall consist of 156 members directly elected on the basis of a simple majority vote under the first past the post system. In Bill 10, it says Article 47 is amended by the deletion of Clause 2, the substitution thereof the following: elections to the National Assembly shall be conducted under a mixed member electoral system as prescribed.
That's right.
Full stop.
As prescribed, yes. So we don't know. So that is when you say.
Two issues here. Number one, we don't know what the actual by deleting Clause 2 of Article 47, which references Article 68. We now don't know whether Parliament will have 150 members.
We don't know.
Whoever wakes up can decide how many members.
Precisely.
And we also don't know who these mixed members are.
We don't know.
Okay.
We don't even know what system. There are various systems around the world.
So for all we know, it may not be youth, disabled. And
nothing. There is nothing.
It could just be friends of friends.
It can be anything crazy. Okay. That's the point I'm making. Because whenever in the Constitution it says as prescribed, it means it to be contained in an act of Parliament. So even the point you have brought about is very important. So we won't even know the composition of the National Assembly. Right now, the composition of the National Assembly prescribed in the Constitution. Now it will be contained in an act of Parliament. So Parliament itself would decide on its own composition. What more crazy situation are you asking for? What would have been logical is amongst the known models of representation, they should have chosen one and embodied it in the Constitution. Then would have had a meaningful debate. Then the disabled would have seen how that particular system benefits them, rather than being told by the president and others lies to say that it will benefit them. There is nothing there.
So if it had said, I'm just going to now shooting off the mark here, but if it had said a mixed member electoral system where 50 women, 50 youth, 50 disabled, this is a totally different conversation.
That's a different conversation. Okay. We don't know. Okay. Because, for example, there is a system, for example, because in other system, for example, they reserve seats. Okay? So many seats for women, so many seats for youth, so many seats for the disabled. There are systems like that. You can devise any system. But right now, this bill has no system that has been prescribed. It is yet to be prescribed. It is yet to be announced. We don't know what it is. How crazy can that be? And you want to run a country in that manner, based on assumptions, when we don't even know what system is being prescribed. Now, how can somebody support a system you are moving from a clear position, which tells you on the composition of your MPs and how they get elected. You're now going to a system, approving a system which is unknown. Okay? It's crazy. Now, whatever system you come up with, we're not saying you can't change the system. That system was rejected. First of all, we had one system that was prescribed, which was rejected. In fact, the system that they adopted was the South African system, which they adopted. But that was rejected. They said, listen, it's too complicated for our people to understand. The parliamentary debates are there. Okay? So even if you come up with a system, what is required? Put it in the Constitution, not in an act of Parliament, so that there is no doubt. Everybody can read it.
And the dangers of putting it in an act of Parliament is anyone can wake up one day and decide to make amendments.
That's right.
Of a simple majority.
That's correct. Because the problem is that in our system, the way you amend an ordinary act of Parliament and the Constitution is different. Okay? For an act of Parliament, it's a simple majority. Okay? In fact, under our system, first of all, you need is about half the members of Parliament can form a quorum, and a simple majority on a bill is that other half the number. So you're talking about 40 people can change the law. Now, for a constitution, you need 2/3 of all the members. And that is why you're having all this trouble with Bill 10. That is what the Constitution was designed for, to make it difficult. So that if you have to amend the Constitution, it has to be a bipartisan product. Not, you see, the party sponsoring Bill 10 has to seek the cooperation of the other political parties. In the absence of that, the issue can't go through. And that is how the Constitution is designed. It is designed to make sure that no person can amend the Constitution at will. That is what it is designed for. And what you're seeing is the Constitution at work. What you're seeing is Article 79 at work. That is why they end up bribing. And in fact, it will be a scandal and a violation of trust for an MP to accept a bribe in order to vote in favor of or to take it to sell his vote in the assembly. It is a betrayal of the oath that the MP has taken, and it is a betrayal of his members of the constituency, if at all he is to personally benefit through that particular process.
But that's just one. I know you said that you don't. It's a simple argument.
Yes.
But it is just one bad clause.
No. But look at it this way. Since they haven't told us the benefit, remember, we didn't sponsor the bill.
Also, you don't have to make the case. They have to make the case.
They have to make a case. It's not for me to make a case. They are sponsoring. They made a decision to amend the Constitution. They have to convince the citizens the benefits. It is not for the citizens to tell them what is bad. No. Because the citizen didn't ask for this. It is the politician, it is the president and this cabinet who decided to amend the Constitution. It is them to make a case. But even if, for those of us who are opposing, we can make a case. For example, let's just start with one thing. Can anybody tell me why you have to amend the preamble and other provisions to exclusively provide that Zambia shall be a Christian nation? What benefit is there? I have not heard any argument to justify that. I've been a Christian all my life. I do not need a constitution to practice my faith. And in any case, I strongly believe that matters of faith are personal. You are at liberty to hold your faith. I have the freedom to hold my faith. It is not the responsibility of the state to declare what religion it is that should be favored in a country. And what you're doing is you're trying to make people of other faith to feel like second-rate citizens. Okay? Matters of faith are personal. So, I've not heard any argument. Can anybody think about why you'd want to create that problem? Has faith been a problem in this country in the last 56 years? No. So why do you want to create a problem where none exists? Okay? I can tell you other provisions. For instance, just to pick up at random, because there are many.
Yeah. Yes, almost as many.
Yeah. Now, let's look at it this way. We have a provision in the Constitution which protects political parties. Okay.
Is it Article 60?
Just check it out, please.
Is this the one that refers to political parties?
Yes.
Yes, Article 60.
Yes. Now, Article 60, if you read from the original text, it seeks to protect, okay, members of a political party. Okay? Do you have the original text?
I have the original text with me.
Can you read it?
A political party has the right to disseminate information on social and economic programs of a national character and of its political ideology, sponsor candidates for election or nomination to a state office in respect of which elections are required to be held, and conduct primary elections for the selection of candidates. Should I continue?
Yes, I think
right.
3. I think. Is it 3?
Let me go to 3 then. A political party shall not be founded on a religious, linguistic, racial, ethnic, tribal, gender, sectorial, or provincial basis, or engage in propaganda based on any of these factors, engage in or encourage violence or intimidate its members, supporters, opponents, or other persons, engage in corrupt practices, and, except as prescribed, use public resources to promote its interest or that of its members.
Now, there is a provision in 60, Article 60, sub-article 2, E and F. Okay?
Okay.
Now, E and F, it says a political party, okay?
This is in the original text.
In the original text. Okay. A political party shall respect the rights of its members to participate in the affairs of the political party. F. Respect the rights of its members to seek redress from a court or tribunal when aggrieved by a decision of a political party. Right? Now, this clause has a long history. You know what Bill 10 seeks to do? It seeks to repeal provision E and F. Now, this is designed to introduce democracy within a political party, encourage the participation of members of a political party in the affairs of a political party, and if there is a grievance, they can go to a constitutional court for redress. Now, can anybody tell me why you'd want to remove such a provision? Why? Now, the rationale for this, it has a long history. What has happened in the past is that political parties were treated as clubs, whereby they can feel at liberty to expel their members and so forth without recourse, just because the decision of the majority have decided. Now, during the debate of the Constitution after 2011, there were concerns. They said, no, we need to find a way to protect the political parties. Now, what this Constitution amendment did was to elevate a political party from a status of a club into a constitutional body so that it is accountable. Now, remember, you vote a political party, but we have no control over a political party. Now, the Constitution now is telling us that no, political parties are subject to the Constitution. And including the members, it is encouraging participation of their members within a political party. A member of a political party has the freedom to contest any position in his political party. And if there is anything is aggrieved with any decision that has been made, it can go to the Constitutional Court. Now the question is, why would you want to remove a clause like that? Why? Okay? Number 2, if you look at provision under the original, the other provision is Article 52. Okay? How can somebody then want to repeal Article 52?
This is in regards to nominations.
Nominations, yes. Why would you want to repeal it? Bill 10 seeks to take out completely Article 52.
What does Article 52 do?
What Article 52 does is this. It addresses presidential candidates, mayor candidates who are contesting as councillors, and MPs. Now, on a date appointed, by the Electoral Commission. Any person wanting to contest as president, MP, or a councillor has to file in his nomination papers. Now, that is the beginning of the process. It is only when you have filed those papers that we know your intention to participate, to contest in the election, either as president or MP or councillor. Now, within that particular process, the National Assembly, remember, we're not dealing with election. We are simply talking about your eligibility to contest as president, MP, or councillor, right? Now, the ECZ can reject your nomination papers at this particular point to say you don't meet the qualifications. If the ECZ does not do that, then any citizen can go to court to say this person is not eligible to stand as either as president, councillor, or an MP.
And they need to do this within 7 days.
It has to do that within 7 days. 7 days, you forfeit your right to do so. And the Constitutional Court has, I think, within 21 days to make a decision. Okay? It's a vetting process. What you don't want, you don't want a person that is not eligible to appear on a ballot. That is the rationale. Now, can somebody tell me what is wrong with this provision? What is wrong with this? Okay? If you remove this, the implication is likely to be, but of course, I mean, we can always be creative legally, but the implication is this: the only time you challenge a person is after the election. Okay? But the idea is, the Constitution has provided for a two-step system. Challenge the eligibility and challenge the election of a person. Okay? Now, can somebody give me a rational explanation why you want to remove this clause?
Maybe it's a cumbersome step.
What is?
Or maybe let me be creative as
yes.
well. Maybe not just it being cumbersome, but maybe if I don't like you, John Sangwa,
yes,
and you decide to stand as a mayor, I can challenge before a court your nomination.
Yes, which is your right.
But I just don't like you.
It's a constitutional
but I just
right.
Don't like you.
That's fine. That's why there is a court. There's a constitutional court which is independent and impartial. They'll look at you to say, "Hey, Mr. Humbert, your petition is useless. It has no merit. We're condemning you to pay cost." There's a penalty for going to court on a useless case anyway. Okay? But it is your right. But even when you cannot simply wake up to say you can't contest as a mayor because I don't like you as a councillor. No, that's not the premise. It is the law. There is a requirement to say, because there is a stipulation as to whether you have met the requirements to stand as a presidential candidate, as an MP or a councillor. So when you formulate your petition, you should be able to state and explain why you think this candidate does not explain. If your application is frivolous, but in any case, who is to say that it's frivolous? You go to court and let the court tell you it is a right that has been vested in the people. The people to do that. Now, can somebody make a case why you want to remove this? Okay? I'm not persuaded that there is any cause to remove this. There is another provision. Let me go to the more serious one. We have an amendment, a suggested amendment. Oh, by the way, let me put a caveat. There is this suggestion to say, oh, there is this bill which contains parliamentary proposed parliamentary amendments. Now, that is rubbish. That document has no legal foundation. It has no legal basis. The only official document we have is what is before the assembly, and that is what we should be discussing, not the copy that was published in the newspapers. That is a fake document. It has no legal basis, no legal foundation. So that's what we should be discussing. Okay? Now, when you look at, there is a provision. Why would you want? The law says.
Do you want to tell me what the provision, what article I'm looking at?
That would be Article 100 and
We apologize, by the way, to anyone who's following and waiting for the silence, but it's important for us to try and go through this so that people can understand, what's going on.
Yes. If you look at that would be article. Sorry,
It's not one. Is it 101?
Should be 101. Yes, should be 101.
Repeal and replacement of articles 101, 102, 103, 104. Election of the president. Okay.
That's the one. Now, it's crazy. This is even crazier. Now, we have a position where the law says if you have to be elected president, you must receive 50% plus 1 votes to be declared winner. Now, Bill 10 seeks to amend that. Now, the law as it currently stands, it says that if there is no outright winner, you go for a second run. Right? Now, the Bill 10 seeks to change that to say, no, it should be possible to create some fictitious coalition. Now, that's crazy. It's crazy, totally crazy, because nobody, first of all, has even thought through how that would work in the first place. And also, in making this, people have forgotten the background to this particular provision. The background to this provision is 2001, where President Mwanawasa was elected. He became president with less than 30% of the votes. And what the people were saying is, we need a popular president. Now, how do you determine the popularity of the president? A president that is acceptable by all Zambians is a president who gets more than 50% of the votes cast. That's the system we have in place. That system was received bipartisan support in 2015. Now, can somebody tell us why you would want to change such a system? Okay? It worked in 2016. President Lungu got 50.3%, and he was declared winner. Of course, it was contested. That is what is expected. Now, why would you want to create a fiction of a coalition government? Because what you're trying to do is basically to avoid conflict. And that is exactly the position which Malawi found itself in. Malawi, the court had to declare to say you need a 50+1 system. Now, why do we want to water that system down? Okay, I haven't heard anything to that effect. And first of all, who has made a case about the beauty of such a system? Okay, what are the advantages? What advantages? What do you hope to achieve by changing the system in that manner? Okay, these are some of the problems. Of course, we all know about this crazy idea of introducing deputy ministers and so forth. Obviously, it has no support, but it is there in the bill. So we can only talk about the bills that are there. Now, the point is this. Some of the changes proposed changes are basically a ruse. Okay? But at the end of the day, there is no single provision that improves the Constitution as it stands. Every provision in Bill 10 seeks to take away from the Constitution, seeks to undermine the Constitution as it stands. Those that have a different view, let them come. Let them address the people. Let them show. Don't just claim Bill 10 will address the economy. Bill 10 will address chiefs' wrangles. Bill 10 will address, will improve. Mention specific provisions. Mention specific provisions. Okay? So that make a case how these proposed changes will benefit the people.
And as long as anywhere where it says as prescribed, regardless of what it says beforehand, it should be treated cautiously.
It's unknown. Okay? Now, you cannot have fundamental constitutional principles and ideas contained in an act of parliament. All provisions of constitutional significance must be contained in the Constitution itself. The Constitution must be complete in itself. Okay? Now, whatever you have there is crazy. A lot of those provisions says prescribe, prescribe, prescribe. We don't know how they'll prescribe them. We don't know. Okay? So there are a lot of other things that are totally, completely useless. And all these things are all designed to undermine the Constitution, not to beef it up. No. You already have a Constitution. The essence of amending a Constitution is to make it better. Now, who has made a case about how Bill 10 will improve the Constitution from what it is? Who? I haven't heard any. I'm interested to know.
And it's not enough to just say. It's not enough to just say that Bill 10 says that there is mixed proportional representation. Bill 10 says that chiefs and wrangles will be sorted out. Bill 10. That's not enough.
It's not enough. Go to a specific provision. Marry what you are saying with what Bill 10 says. Okay? I can tell you that the Constitution protects political parties and its members. And I'll point you to Article 60. Okay? And I can tell you that the Constitution provides for a majoritarian president, a president who is elected by the majority. And I'll take you to Article 101. Okay? And then you have other provisions, for example, which they want to repeal. Where, for instance, there is a petition, and the petition is against an incumbent president. The Constitution as it stands says the incumbent president will vacate the office, right? Once there's a petition. And during that period, the Speaker will act until the elections are held. Now, why would you want to remove that? And there is a rationale for that. That is designed to ensure a level playing field. Because if you have an incumbent who is now who's been petitioned, okay, what is supposed to happen is that to create a level playing field, the Speaker must take over. The Speaker must be independent. So that because left alone, the incumbent will use the instruments of power to his advantage. Okay? All these provisions were carefully thought through. Okay? They didn't just come from out of thin air. People, the technical committee spent months, they spent billions of kwacha in coming up with the Constitution as amended in 2016. So you cannot just amend it like you are amending a letter or a secular, and then without care, without even bothering, you just want to amend it at will. No. This is a national constitution. Make a case. Make a case. And so far, these people have not made a case why we should support Bill 10. Okay? And in any case, like I've said, this is a lame duck parliament. It's a lame duck parliament. We're talking about a president who has 13 months in office. The National Assembly only has 10 months in office. It should be what? 11 months, I think, in office. Why should they be pushing a major amendment to the Constitution? Why can't it be left for the next government, whichever government it will be, which will receive a fresh mandate? Okay? So the point is this. The Constitution, as it stands, as amended in 2016, is the best Constitution we have ever had in this country. It is the responsibility of each and every Zambian to protect the Constitution as it stands. Nobody, I have not heard any sound argument to justify Bill 10, other than lies, other than general statements being made.
Okay. I want to ask a couple of people to call in. Maybe you might hear an argument that pleases.
Yeah, sure.
That pleases you.
Or opposes me.
Opposes you, exactly. Hello, good morning. Hello, good morning. Good morning, morning. You're live on radio. What's your name? Oh, okay. All right. Listen, when you call the radio station, please make sure that your radio is off. Hello, good morning. Morning.
Fine, thank you. This is Max from Virginia on the line.
Yeah, Max, go ahead. Max, your line is really bad, Max. Listen, try and call back. 226-841. Hello, good morning. Yes, it is. You're live on radio. What's your question?
Wonderful. We are talking to Dr. Mainza within Lusaka. But John Sangwa Mokapwani.
We don't.
Tilina mavuto under PF yamene vatifuatika ivomere vyute. Pamwavuto kuza kuliba minisa na mbele mzambie. Ikupemperelani kuti mupitirize. So that if constitution is a personal law. We want by 14 hours in there kuti bill 10 ya kwa kukwela. We want to buy bill 10 including wana yote wa CF. We want to buy together. Kuli buy funa. Now, nina question wa John Sangwa.
Yes, sir.
If you want to Kenya, then the PF, they are using their own means to keep it passing bill 10. Itapezeka ya pasa mjia zao kuruku. What next? And the majority of Parliament, you can through bill 10, you don't have to tap in for there.
All right, so there were two questions. Before you respond, I think the Deputy Secretary General of the Patriotic Front may have a compelling argument for you. Good morning, ma'am. How are you?
I'm fine, thank you, Uchi. Good morning.
Morning. So,
good morning, Council Sangwa.
Good morning.
My fellow Musubiran. Uchi, it's very unfortunate that you have given us very little time to call in and verify something. My dear brother Sangwa, are you telling me that the things which came through the select committee, where even as Patriotic Front submitted that we didn't want a coalition government, from your understanding, are you saying the select committee is useless? What was discussed will not put into consideration? And as I said, for me as lawyers, I'm sure as a woman, for several times I've said, it's very unfortunate. If the situation we are having in labs was happening with the doctors, I think if we were in that one, because it's like when the constitution, the last constitution which was enacted by President David Alonso, you were called to be part of the constitution making process by the MND. The signatures which are in the public domain, it was so unfortunate. You couldn't even tell which lawyers signed for that. Is that the way of operating?
But is there a compelling argument? Is there a compelling argument, Mr. Sangwa? What's the compelling argument?
My question to Mr. Sangwa is, he was talking about coalition government, and we have submitted to say as the party we don't want it, and the others who said that. So is he telling us that the select committee's meeting was useless?
Okay.
Because those things do not be considered.
Okay, that's the question. Thank you, ma'am. Thank you very much.
Okay.
Another one too, and then I'll see if I can go back and
Yeah.
have a few more.
Okay, yeah. I mean, this is the confusion which PF has created itself. And when you now have a bill, like the one which was gazetted in June, which has all those provisions deleted. Now, first of all, they have not clarified. Okay, how do we treat the two instruments? You have what they have gazetted, and there is what is in the National Assembly. Now, as I've explained, there is no provision to change the bill which is in the Assembly outside the Assembly. Okay, there is no such a provision. This is the problem they have. Now, they have an easy way out. If they want to change it, fine. What they can say, pull out the one which is before the Assembly, pending a second reading, let them pull it out. Then they can now represent the one which was gazetted in the National Assembly. Then that becomes the official bill. Now, the implication of that is, it will mean restarting the process all over. Okay? But they can't do it both ways. They can't. This is an unofficial document. It has no legal foundation whatsoever. But the official bill is what is in the National Assembly. So what she's talking about is that, yes, the party, they have said that the party has made representations, but we won't know until the final bill comes out of the assembly whether these were simply, because first of all, whatever the select committee does is not binding on the entire assembly. Okay, the decision is that of the assembly itself. The process in the assembly is not yet complete, so we'll only be able to pass judgment once the process is out of the assembly. Now, if, let's say, by some whatever happens, the bill passes through, we'll evaluate it. But right now, the only bill we can discuss is what is in the assembly, not what was gazetted in June. Okay? So that is, I think the other issues were.
The other issue was how many numbers, the numbers
Yeah,
that you
need to calculate.
And what happens if it passes?
Yes. Yeah. You need to calculate, because it's not there's been a bit of confusion. I knew what the number was, but I've just forgotten. You need to calculate whatever the composition of the assembly is, 2/3, okay, of the members. It's not about members present and voting. No, even if somebody is dead, is an MP, or is sick, you'll be counted as part of the number to constitute the 2/3. So it's not an easy number to reach. Okay, so my arithmetic is not one of my strong suits. Yeah, anyway. That's right. So, but whatever the number is, I know there's been debate already about whether the speaker is part of it and everything. There's been a bit of that debate as to what the real number is. But again, at the end of the day, I think there is a huge debate as what would constitute 2/3. Yeah.
All right. Hello. Good morning. Hello. Good morning. Morning. What's your name? Mwemba. Go ahead. Councillor Johnson was listening. Go ahead.
Yes. I have one question for State Council Sangwa.
Yes, sir.
This question is about representation of the UPND during the period of
the petition.
Yes.
Yes.
The petition.
Yes.
I'm sure Dr. Sangwa was one of those who represented UPND.
Yes.
And they cried of the period of time that was short.
Yes.
What has changed now that they want to amend to increase on the time?
Yeah.
Why is it that Dr. Sangwa now is against that?
The provision.
Mm.
All right.
Yeah, let me explain. We went through a process. There was a confusion both on the part of the courts and other parts of the lawyers as to the meaning of 14 days. Now, the initial view, I think you can check the transcripts of the court for those that are interested. The initial view of the court was that, now, this was the view of a single judge of the court, was that, well, it is okay. And I remember vividly at the first sitting of that particular case, I brought it up to the attention of the single judge, and I said, my lady, this is a time-sensitive case. And the response of the single judge was that, well, it's okay as long as we start within 14 days. That was the initial view. If you read the transcript of that particular case, the view of the meaning of the 14 days evolved until the last, I think, 2 days before the 14-day expired. Okay? And that was where the problem was. But if there was an understanding from day one that 14 days means the beginning and the end of the case, we would not have had that problem. But that is no longer a problem because the law has been clarified. So everybody knows, those that will take part in the God forbid there is an election petition next year, they know very well that they have to start and get ready. They have to file the case, start the case, and finish within 14 days. Now, I do not agree that if you push it to 30 days, 50 days, 60 days, it will change anything. 14 days is more than enough. to argue the case, because other countries have done it. Now, don't forget, I was a lecturer at the university. I used to give my students an assignment. I can give them 30 days. Do you know when they actually started working on the assignment?
On the 29th day.
Yes.
Yes.
Okay. It's a natural human behavior. Yes. I mean, we all played truant as students. So the fact that you see, and then I started giving them 7 days. So it doesn't mean that when you give them 7 days or 30 days, they'll come up with a better assignment in 30 days than they would in 7 days. No. So whatever time is set, the rule of law demands that you respect the law. If it is 14 days, it is 14 days, irrespective of the consequence. The problem with that particular case was the idea of 14 days evolved. Now, the way we understand it now, 14 days would include Saturdays and Sundays. Okay, so we don't expect, so the Constitution has grown. We have breathed life in the Constitution. So the idea is not to amend that. We don't need an amendment. So everybody is clear. The court will work within 14 days and deliver with the judgment within 14 days. And also the court has the right, for example, or what we need to do, like they happen in Kenya, for example, they said to the lawyers, guys, you have 2 days to present your case. You other guys have 2 days, and we have 2 days to deliver. The court can set a timetable. And if you don't comply, it's your problem. If you have 2 days, you have 100 witnesses. You have to decide how you're going to. You have to give priority to your case.
That was going to be my next question.
That's right. So
the confidence to be able to finish and deliver it within 14 days.
Yes. Yeah, so we manage that. And in any case, most of these election petition is done on evidence. You can put together your evidence and then put your evidence before court. The court can evaluate that. And not only that, the court can make a preliminary decision within 14 days. They can say, for example, we have concluded this person was validly elected. We will give our reasoned judgment later. Then they can take months, weeks to write the final judgment. But at least they have decided that case, which is what I think they did in Zimbabwe. Okay, and I think in Kenya they did the same thing. So it is doable, and that is why I'm not in favor of increasing it to whatever, even 15 days. 14 days is more than adequate. Or what is required is discipline for people to prioritize things, choose the right witnesses they want, choose the evidence, because it also eliminates the opportunity of having frivolous or useless evidence and witnesses being called. We always have a saying, if you can't make your case with 5 witnesses, then you'll never make your case, you know. So it's not a problem. That is the reason, okay? The problem is that we can never agree. The moment you change that, why can't you also change another period? Where are you going to stop, you know? Because the next thing you say, oh, it's not adequate for the judges, they need more than 14 days. The next thing you say, oh, by the way, there is that provision which says 21 days. 21 days is not enough. Can you increase it to 30 days? Where are you going to stop? You have to accept the limitations set by law. You know, it reminds me when I was a lecturer, students would get 49%. And one student would come to say, but sir, I only got 49. Why don't you give me 1 mark to make 50? Then I said, well, if I give you 1 mark, the other guy who got to the 48 will also say, listen, you give me 2. The other one will say, I got 47, and then give me 3 because you've given my other colleague 2. The point is that our system will collapse. Even when students got 49.5, according to the system, they failed and never gave an extra mark to any student so that they can pass. No, 14 days is 14 days. 21 days is 21 days. That is what the rule of law is all about.
Okay. Hello, good morning. Hello, good morning.
Hello, good morning.
Good morning, how are you?
Fine, thank you. Good morning, Councillor Johnson.
Good morning, thank you.
What's your name? Conrad, go ahead.
Yes, I've followed the program right from inception, and clearly you tell me fact with defeat, because quite a number of people really didn't understand it, and I believe most MPs and most ministers do not even understand some of the things that Council has explained here. But of course, the ruling party will obviously be voting as a block vote.
never mind if one person understands the document or does not understand it. Now, given that scenario and the arguments that you have forwarded here, Council, what is the immediate remedial action for us, the citizens? Obviously, you are not going to be in Parliament. What is the next best course of remedy available to us? Is it the opposition? What happens this afternoon? What is our course of remedy?
All right. Just before you respond to that, let me add another call. This is from Boniface Chamber. He is from SACOD Executive Director. Mr. Chamber, good morning. How are you?
Thank you, very good morning to you, and good morning to the Council, Sangwa.
Thank you.
Go ahead, Mr. Chamber.
Yes, thank you very much, Luigi. I just wanted to follow a couple of things. I have followed the program very, very well, and thank you very much to the Council, Sangwa, for your insight. I'd like to get a starting point in terms of the explanation of what the Constitution is and how the process of constitutionalism should be about, especially from the point of view of viewing processors. If you remember, the starting point of the current constitution-making process was the decision following the 2016 elections. There was a traffic offense that brought about tension, and then the Commonwealth was actually invited in the country to bring about some kind of peace on the tension that was already in the country as a result of the 2016 general election. Of course, the 14 years period was one of the issues. But what the Commonwealth did very extensively was to consult widely on really what the issues and the problems were in Zambia. They spoke to many stakeholders, and out of all the stakeholders that submitted before the Commonwealth, I think they came up with 4 issues. One of the top priority issues that was deemed to be problematic for stakeholders in Zambia was the Constitution, and there was consensus from that point of view that we needed to attend and address issues that we thought were problematic as a nation as regards to the constitutional process. And of course, they did come up with a web plan on how that was going to be done. And that web plan more or less resembled the National Dialogue Forum, although it was going to be a national peace architecture because it was going to be much more long-term as opposed to it being ad hoc. But following the process of the Commonwealth undertaking their consultative process, even after they left, those who were willing to be possible people to follow on what the Commonwealth had undertaken, such as the church, the Zambia Center for Interparty Dialogue, the issue of the Constitution was still the top priority, and that issue has never seemed to be a top priority to date. Now, there has been consensus and there has been agreement in that regard that the Constitution has to be addressed. So I wanted to find out, State Council, from your vantage point, when you put across the point that there has not been consensus and there wasn't extensive consultation as regards the current constitution-making process, how do you assess what the Commonwealth did to basically give us the constitution reform process as a top priority, and it has been taken on board by pretty much all other stakeholders and the issue of priority has never changed. That's number one. Number two, the issues of the economy, for example, that you brought to the fore and other factors that you believe should be a priority, where they are deeply during the 2016 or after the 2016 general elections. They were there, but they were seen not to be as a much more of a priority compared to the Constitution. So at what point would you assess or would you say that you need to drop the issue of the Constitution being a priority agenda from the very start in 2016? I think I would appreciate if you had to basically shed some more light on the issue of consensus building on this particular matter, which I think has had a very long process starting in the Commonwealth, and that is still the case to date.
All right. Mr. Chamber, thank you very much. Thank you very much. Do you want to respond?
Yeah. You know, there is a reason why I started off by explaining what a constitution is. Now, you know, there will always be challenges with a constitution. It doesn't mean that because you have encountered a few challenges, then the answer is to amend the constitution. No. Then the question is, how many times are you going to amend your constitution? Okay. Now, the Constitution...
Can I argue with you slightly? Sorry,
yes.
But I just need to say, so America continues to amend their constitution. Well, they make amendments to provisions. And you're shaking your head. I feel like I'm back in school. That's the wrong argument there.
No, they still, in fact, theirs is the oldest constitution. Yeah. Okay? Now, the point that I'm making is this. You know, when you say there's a problem with the Constitution, where are you coming from? What is your reference point? Okay? So, because if I ask you, you find something wrong, everybody will find something. But whatever you perceive to be wrong, does it rise to the level which should justify an amendment? Now, some of the problems that we have had, they have nothing to do with the Constitution. They have everything to do with the people responsible for the running of the various constitutional offices. Now, if there is a failure, we have to identify where is the failure coming from. And that is why it comes down to this. The Constitution is as good as the people. You can have the best Constitution in the world, but if you have the most useless people to run it, you never see the benefits. That is why it is important to have the right people in the right places in order for the Constitution to work fully. Okay, that is something that has to be understood. I have not seen this report from the Commonwealth. It's easy to say the Constitution is a problem, but it's a problem in what respect? Okay, that is why if, let's say, they had identified that particular issue, okay, for example, if Bill 10 dealt with just one issue, to deal with the fact that, you know what, we have a problem. We don't think at all, given the resources and our experience and everything else, we can execute an election petition within 14 days. We would like to increase it to 30 days, right? And an argument made like that, I don't think at all there would be a problem, as long as there is national consensus around that. Remember, the Constitution is not supposed to serve a small sector of the population. There has to be national consensus in that respect. I am not in favor of amending the Constitution whenever you feel like. No, because what you are doing by amending the Constitution that way, you're undermining rule of law. The Constitution will bring about inconvenience. That is what it is designed to do. Okay? And it is you respecting the inconvenience and allowing the Constitution to stand. Because if you keep on amending, what are you doing? It's like you find this provision you don't like, you amend. This provision you don't like, what are you talking about? That is not rule of law. That's rule by law now. But the Constitution itself says we have to promote rule of law. Okay? So if there were specific amendments, okay, specific provisions, but the point is that has the court, the constitutional court, failed to address that issue? Okay, because that's where you go. I have a different view. Another person has a different view. We need to test our constitution before we begin to change it. You know, like I've said, the issue of the 14 days. For example, we had another case where we said, is it right for MPs, for ministers to remain in office after the National Assembly has been dissolved? Okay? The president's view was that they have the right to stay in office.
Actually, the president's view was you haven't read.
Pardon?
The president's view was you don't read.
Oh yes, he told us that we don't read, right? Yes. But we went to court, and the Constitutional Court said no. When the National Assembly dissolves, you also vacate your position. You cease to be ministers, you can't get the money, pay back the money. What more do you want? The Constitution has been vindicated. But you know what Bill 10 is trying to do? It's trying to change that, so that MPs, the MPs who are ministers, continue in office until election. Now, how is that beneficial? The whole reason of requiring everybody to resign is so that, because in any case, what work do you do as a minister during that period of election? Your job is to campaign. So why should you be paid as a minister whilst you are campaigning? But in any case, during this particular period, you still have access to government resources, and that gives you an undue advantage over the other political party, or over the other contestants. That is why the Constitutional Court said, if National Assembly dissolves, if you are a minister, you vacate your seat. You cease to be minister. You don't have access to your office or the emoluments or facilities of your office. You become an ordinary person. What is wrong with such a judgment? What is wrong with that?
Is it right then to say at that moment the Constitution worked? But then can I also go further and say that it was a mistake by those who framed the Constitution in the very first place, because the idea at the time was that ministers would come from outside and not from inside. And so by dissolving Parliament, they're still in office.
No. Okay, let's assume it was a mistake, but it wasn't a mistake. This is the nature of our parliamentary system. Now, remember, our system is not a full-fledged presidential system. It is a fusion of a parliamentary and presidential system. From independence, okay, ministers have been appointed from the assembly. The moment the assembly is dissolved, they cease to be ministers. That is the background to this issue, okay? And because our system of government, even after to 2016, has not changed. It is still a presidential parliamentary system. And what the Constitutional Court did was to enforce that tradition backed by law. Okay? So that is what the court did. But in any case, there is now clarity, okay? Because we had a debate. People said, no, I can still continue. Other people said, no, you can't continue. The Constitutional Court settled that issue. So now we know. Come 3 months, we're talking about what? May? Is it May? Maybe what? May next year? Whatever. 11 months from today, the National Assembly will be dissolved. And all the ministers will stop being ministers. We now know. That's what the law says. You know? So at least that is why you need the courts. There will always be disputes over the Constitution. But the answer is not to change it.
Because you don't like the outcome.
That's right. You don't change it. Because when you change it, where are you going to stop? Another president will change it. Another president will change it. No. You respect the Constitution. You can change an act of parliament at will, because that is a born out of policy. For example, you have created the National Roads Board, right? Fine. It's not in the Constitution. It's in an act of parliament. Another government can come into power and say, listen, we don't want the National Roads Board. Let's create another institution. They'll create another institution. That is policy. But you cannot treat the Constitution the way you treat an act of parliament. That is why institutions like ZRA are governed by statute. Okay? Because another person will come and say, no, ZRA is ineffective. I want to change. Let's put in another act. We'll call it National Revenue Services and so forth. Whatever name. That is policy. But when you're dealing with the Constitution overrides policy. And your policies as a government must be consistent with the Constitution. Policies cannot override the Constitution.
Okay, I'll take a few more calls. I hope I can keep you here until 11:30.
Sure.
Okay, cool. Hello, good morning. All right, thanks. How are you? What's your name?
Well, thank you. This is the WM.
WM, just go ahead with your question.
Yeah, actually, it's a statement I need to make.
Okay.
Over the pen. I'm wondering why only PF cadres, sympathizers, are supporting your state. Anyone can spell a right. Because even cadres who do not understand law, who are sympathizers of PF, are supporting Bill 10. So anyone can smell a rat. Okay? It's not a good bill. Okay? Every well-meaning Zambian shouldn't support that.
All right. Thank you. Thank you very much. Let me take a few more. Hello, good morning. Hello, good morning. Hello. Good morning. How are you? I'm all right, thank you. What's your name?
Mary Matala Shoga.
Mary, go ahead.
Yes. Good morning, John.
John Sangwa.
Good morning, thank you.
Yes, Mary Matala Shoga. Vacanza, the Mary Matala Shoga, from the chapter. We should change the CF. That fundamental Sangwa. But talk about it for that to change, which is people. We need to compare one now. But the person I'm going to the number of control of the party. So, you know, I don't know what I take one way. No, that
Mary, thank you.
Okay.
So why the determination? Church, Laz, yourselves, and others don't seem to want it. On people who want it are surrogates and those who support the party.
Yeah. I mean, that is where the problem is. Like, this is what we've been talking about. That, you see, it's a national document. It cannot be advocated for a small section of the community. You know, I mean, it's a valid point, but only PF people can answer that. You know, but therein lies the problem, and the sad part is that, you see, they have not communicated effectively as to the benefits, and I can understand why, because there are none. If they are there, we would all be able to see it. For instance, in 2016, when I'll go back to 1996. In 1996, when Dr. Chiluba pushed through the Constitution, we didn't sit idle. We went to court. We said, no, this is not the way to use the Constitution. This Constitution is targeted at Kaunda. We argued that case. We went to court. We lost. That case, that amendment is responsible for the demise of UNIP. It is that case and the behavior of UNIP subsequently. That's what killed UNIP. A constitution is not a political tool. It is supposed to be a neutral document to govern the entire republic. In 2016, immediately 2011, immediately when President Sata was elected, I was one of those people who agreed with him that yes, it is possible to put together a constitution within 90 days. But anyway, that didn't work. But come 2016, there were a few colleagues within the legal profession who came up to say, no, let's challenge the bill. Then I said, why do you want to challenge it? Can you tell me the disadvantages that are there in this bill? In fact, it was labeled as bill number, I think, 10 of 2015. I argued, and at the end of the day, they could not convince me as to the disadvantages of this bill. And as you saw, that bill received bipartisan support. Both UPND and PF supported that amendment of 2016. Now, if PF and UPND were partners in 2016, why can't they be partners today? Now, if you put something together, why should one of you be responsible for its destruction? Doesn't common sense dictate that you get your partner on board and make a case as to why you have to destroy what you built? Okay? So the point is this. Really, in all honesty, I've taken oath to defend the Constitution, and I stand by that because I've carefully looked at it, and there is nothing good in it. They have further added to the confusion, which I think I'd like to refer to just briefly. You know, the publication of the Gazette in June just adds to the confusion. The whole process of amending the Constitution should be simpler for the people to understand. Now, to know what is at play, you know what you need to do? You need the Constitution as amended in 2016. You need to have Bill 10, which was gazetted last year. You also need this fake document which was published in June. 3 documents in order to make sense out of it. Who does that? Who does that? And yet, if you are sincere and honest, you simplify the process. You don't complicate it. You see, because you want a buy-in from the people, you make it simpler, because the Constitution is for the people, not for you. If it is for the people, then make it easier for them to understand and appreciate what you're doing. It took me a couple of hours to make sense out of what the 2016 says, Bill 10 of last year, and the Bill 10 of June, to make sense out of it. Even I was struggling to try and make sense out of it, okay? But my training, my job is all about reading. But what about the common man on the street? because that constitution is also being amended in his name. Where does he first of all derive the time and the expertise to be able to go through that exercise?
And doesn't it confuse him more that there's another document that's in the newspapers that he's being told to read, and yet, depending on who you speak to,
yes,
even though there does seem to be agreement for most people that the only bill in question here is the one that's sitting on the floor of the House.
That's right, because you see, they produce that. They don't even tell us, how do we relate to these two documents? Okay, what is the significance of the June one? What is the significance of the original Bill 10? All these things ought to be explained. How do we look at it? Okay, if they're telling us to say, oh, we have incorporated the amendments of the technical committee, the question is that lawful in the first place? Can you, in the midst of it, gazette the recommendations of the technical committee? Are those recommendations binding on the assembly in itself? Can we buy into that? You know, what is the effect of that? Is the House bound by what the committee has done? The answer is no. So, what they have done, they've done a very bad job. And what they have added is the confusion. You see, anything being done in the interest of the people should be simplified. People should be able to buy in. They can't buy into something they don't understand. The question then, what is your agenda for confusing these things?
I'll ask you one last question.
Yes.
Progressive or not?
Yes.
Progressive or not?
What?
The bill.
The bill.
Is it progressive? I keep hearing people say, this is a progressive bill. Zambian should support this because it's a progressive bill.
Okay.
Progressive or not?
Now, let me say this. It's like you saying, this woman is beautiful. But what makes her beautiful? You can't just make a pronouncement like that. You have to give your argument why you think this woman is beautiful. The same way with Bill 10. If you say it's progressive, tell us. What it means, what you're basically saying is that we're in a bad position. Bill 10 will put us in a better position. That is the only way you can say it is progressive. But the answer is, I have not heard anybody tell us how this country will move forward on account of Bill 10. Like I've demonstrated, what we get are lies from the vice president, from the president, from the minister, from the MPs about the benefits. And I have said, it's not enough for you to tell us to say it will address it. Show us the clause, educate us, show us. If you are saying it to improve the economy, read to us the clause which addresses the economy. And I'm saying there is nothing. Chief's wrangles, show us which clause addresses the chief wrangles. But in any case, we have had a system of resolving chief's wrangles. Okay, there have been so many cases over chieftainship being contested, which have been decided by the High Court. We have the Chiefs Act in place. So tell us, what are the shortcomings of the systems that we have had, which we already have in place? So that's the only way we can determine. Because first of all, when you say it's progressive, what is the problem with the existing constitution? What's the problem? Okay, you don't just change things for the sake of it. Like they say, if something is not broken, why do you want to fix it? It is working fine. And in any case, we have not even seen it work fully because certain institutions have not been created. What we should be looking at is to make sure that the rest of the institutions are created, the rest of the institutions are fully funded, okay? Then we'll be able to make a proper assessment. Certain parts of this constitution are still missing. How then do you want to change when you have not even put in place that which you are required to put in place? It's just crazy, you know? So the bottom line is this: it is not progressive. We are better off the way we are, with all the institutions, with all the provisions of the Constitution in place. You have your articles protecting political parties and their members. It is a progressive provision. There is no need to take it out. We have a provision to say the president has to get 50 plus 1%. It is progressive. It has to be supported. There is a provision, the Constitution does not make provision for deputy ministers. That should remain the position. It should not be taken out. There is a provision in Article 52 which allows us to contest eligibility of a particular candidate before the Constitutional Court. That provision is progressive. It must be retained. It should not be removed. No case has been made for any of these changes. The other changes are basically useless, and there is no need to abolish any of those provisions, other institutions that are created in the Constitution. What we need to do is to implement, appoint people to those positions. Okay? So, in conclusion, there is nothing good about this. We are dealing with a lame duck president, with a lame duck National Assembly. They do not have the right mandate to embark on an amendment to the Constitution. The role of a lame duck president is simply to wind up. He stay in office so that when there is a transition, whoever his successor takes over a better country, a better government, with better issues to address, not confusion.
John Sangwa, thank you very much for coming on the program this morning.
Thank you.
That is today's edition of Let the People Talk. Thank you very much indeed for listening. Uncle Sam is in on Friday for Friday's edition of Let the People Talk. That's this coming Friday. Thank you very much indeed for listening.
Structures. We are specialized in design, fabrication, and installation of steel structures, carports, and shed netting.